clear now.
I'm not playing.
All right, you was here on Munoz.
I am just
Are you confirmed?
no. We could do that later.
Okay. Munoz. Is this going to be a sentencing?
We're gonna ask for a reset for a PSI and a sentence, and there's no application for probation, but since it's a big cap, I'd like a PSI if you don't mind.
So I'm more than willing to do PSI, but if you would like, what we can do is I can reset it not so far off.
Yes.
And you can have chance to bring in witnesses, and then all I'll need is the criminal history, if y'all want to do it that way.
He wants to get this done quickly, so that'd be wonderful.
All right, so we'll bring it back quicker because otherwise it will be a longer setting. Okay. All right, everyone, could you all not talk behind the court reporter? Just ask the deputy, they'll move you down there. Court reporter, hi. I can't see you around the computers, but are you okay with doing two cases at once? It's the same defendant. If not, just let me know. All right, court is calling 2024 CR 007361 and 2024 CR 007359, State versus Johnny Abel Munoz. Could I have parties announced for the record for the state?
Adrian Pettis for the defendant.
And are you Mr. Munoz? Yes, ma'am. Counsel, in each of the cause numbers, have you received all of the discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Munoz, in each of the cause numbers, did you review the document entitled True Bill of Indictment with your attorney? Yes. Did you understand it? Counsel, in each of the cause numbers, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the cause number ending in 6-1, are you proceeding on the indictment as presented?
Your Honor, he's reading count one.
All right, any objection to the waiver of count one?
No, Your Honor.
And you're proceeding on the deadly weapon allegation?
Yes, sir.
And the repeat offender allegation. And then in the cause number ending in 5-9, are you proceeding on the indictment as presented?
Sir, he's reading count one that you're reading before and the other one.
Any objection to the waivers?
No, Your Honor.
And state you're proceeding on the deadly weapon allegation and also the repeat offender enhancement allegation?
Yes, sir.
All right, Mr. Munoz, did you review the documents in each cause number entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Just one moment. All right, in the cause number ending in 6-1 and counts 1 and counts 2, you're charged with aggravated assault with a deadly weapon. If the state is able to prove up the enhancement, your range of punishment will be anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. In the cause number ending in 5-9, you're charged with aggravated assault against a public servant in both counts. If the state is able to prove up the repeat offender enhancement allegation, your range of punishment will be anywhere from 15 years to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes.
By entering plea bargain agreements in each of these cause numbers, you are giving up those rights. Did you understand?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause number, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Munoz, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
All right, on the one off the record, the one ending 359, if y'all could just put in here the counts that you're proceeding on. And for that one, you all said you're proceeding on 1 and 2.
Yes, ma'am. I just finished that, man.
All right, we're back on the record. And cause number ending in 6-1. According to the agreement, the state is proceeding on counts 2 and 3. Your punishment is to be assessed at a cap of 40 years in the prison. There's a $2,000 fine. There's an affirmative finding of deadly weapon. There are no applications. This is run concurrent with 2024 CR 007359. They're taking in consideration 2024 CR 007370 and 2024 CR 5164. Off the record for a moment, please. Then also in the cause cause number ending in 6-1, you're to agree that you've been previously convicted of a felony before for purposes of enhancement. Did you understand that to be the plea bargain agreement under that cause number? Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, ma'am.
And if I can have the other one back. Right. And then in 5-9, according to the plea bargain agreement, the state is proceeding on count 1 and 2. Punishment is to be assessed at a cap of 40 years in the prison. You're to agree that you've been previously convicted of felony, 1 or more, for purposes of enhancement. There's an affirmative finding of deadly weapon. There are no applications. This will run concurrent with 2024 CR 007361. The state will take in consideration 2024 CR 5164, 2024 CR 007370. Did you understand that to be the plea bargain agreement and that cause number? And each of the cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2024 CR 007361, how do you plead to count 2? Guilty, not guilty, or no contest? And to count 3, how do you plead? And to the repeater enhancement allegation, how do you plead? True or not true? And cause number 2024 CR 007359, how do you plead to count 1? How do you plead to count 2? How do you plead to the repeat offender enhancement paragraph? State, any evidence to support the defendant's plea?
No objection.
All right, in each of the cause numbers, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering these pleas, what that means is that the state will present evidence in the form of witnesses' statements and judgments, but most importantly, there will be no live testimony at this phase. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. And the cause number in 6-1. Court will find there sufficient evidence to find you guilty, and the court will find you guilty of count 2 and count 3. The court will find the repeater offender enhancement allegation true based upon your plea of true and based upon states exhibits 1 and attachments. And the court will review cause number 5-9 for sufficiency. All right, this has 1,000 officers at the scene that are listed. All right, after reviewing states exhibits 1 and attachments and cause number 2024 CR 007359, the court will find there's sufficient evidence to find you guilty. Court will find you guilty of count 1 and count 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. All right, counsel, how much time do you need?
I'm thinking 2 weeks, Judge. We're gonna have. I would like ample opportunity to argue at sentencing. So I would think 2 weeks would be more than sufficient.
All right, Norma, if we recall this in 2 weeks, where would that put us? All right, we'll bring you back on September 24th at 9 a.m. And state, if you'll just give me a criminal history.
Your Honor.
Yes.
Do you mind terribly if we make that the 26th?
All right, Ms. Ferguson, can you put it for the 26th? All right, we'll bring you back on September 26th. At that time, I will hear whatever evidence that is presented to me, and I'll base my decision on your sentence based upon, of course, the evidence that's already been presented to me and anything else. You understand? All right, do you have any questions about anything? All right, we'll see you back then.
All right, Johnny. I'll see you in 2 weeks. Okay.
No PSI. Sure, no problem. All right, who's here on Aiden Martinez? All right, so last time we were here, labs are in.
Yes, Judge. Labs are in.
All right, so has an offer been tendered?
Yes, ma'am.
And when was the offer tendered? Was that just today?
It was at the last setting.
All right, so are we going to jury trial or is he accepting the offer?
At this moment, we're going to jury trial, Judge.
All right, so here's the thing. If you want to go to jury trial, that's fine. Your plea deadline date will have expired today. So after that, the court is not going to consider any plea bargaining agreements with not good cause. Otherwise, you're going to have to plead open to the court. You understand?
Yes, ma'am.
All right, so you're asking for a jury trial? All right, Ms. Ferguson, how long will this trial last, guys?
By 2 days. 2 days, Judge.
2 days. You want to set in on the September 17th?
Can I check my calendar?
No, there's no need to check calendar.
Okay, thank you, Judge.
We'll see y'all back on September 17th for jury
Judge,
trial.
we did have some motions that we wanted
Yes.
to have heard. Yeah.
We are where we are.
So, Judge, if I can tender a copy for the court. So The first thing we're asking for, Judge, is for the state to tender notice of its defense expert for the labs associated with the testing of the substance.
All right, State, do you have an expert you're going to call? I'm assuming that would be a yes. All right, so
And if they can identify.
yes, if you'll let them know, give them a witness list and let them know who your expert is going to be. Defense has just, let me see, were these done, these motions done today or?
No, ma'am. They're timestamped at the top. For whatever reason, it didn't print out on my copy, but
Yes.
they were.
Okay, all righty. All right, so you'll need to give him your expert by the 16th.
Additionally, Judge, we called the motion to disclose all witnesses associated with the case. That motion was filed back at the same time as the other motion.
All right, witness lists. Well, actually, this may be easy for the state to do. So with regards to the witness list and the expert, State, are you all able to get that to them by the 13th, your witness list? All right, so they'll get you your witness list and who their expert will be on the 13th.
In addition to that, we have we're requesting formal request of any sort of extraneous bad acts they intend to offer.
Okay.
We're, just for the benefit of the record, we're
We're not on the record yet.
Oh,
Yeah, so I'm just trying to see what motions you have. And with the motion to suppress,
we understand that the court runs it with trial. We just wanted to let the court know we anticipate on asking for a motion press, and we'll follow the court's lead, of course, on that.
all right, we're going to go on the record. Court is calling 2024 CR 2402, State of Texas versus Aiden Martinez. Can I have parties announced for the record for the state, for the defense?
Christopher Ramos and Paul Acevedo.
And are you Mr. Martinez?
Yes, ma'am.
All right, so the defense has presented several motions for a hearing with the court. First motion is for the state to disclose any expert witnesses, and the next motion is for a witness.
Desiree Tina's bond hearing had such a compassionate yet firm vibe. The way Judge Boyd acknowledged her family being there and worked through the legalities made it feel more human. Shows how structured yet personal courtroom proceedings can be.
Witness list, the state, you to tender those lists to the defense no later than September 13th by 5 p.m. And are you okay with them tendering that to you by email?
Yes, Judge.
Yeah.
And with regards to extraneous offenses by the 13th state, yes. And then the motion to suppress, that'll be carried with trial. Just let Judge Angelini know. All right, is there anything else?
One more item, Judge. It's my understanding as the state of the law regarding this substance, alleged substance, including marijuana and THC, it's my understanding that a substance that has less than 0.3% of THC does have a legal implication in a trial. As a result of that, we would be asking the court for maybe a copy of the jury charge that it intends to present to the jury so we can start reviewing that and tailoring our defense for that, dealing with the 0.3% threshold that is my understanding is part of the law. And in our review of the discovery, that information is not included in the discovery. I mean, the items were tested, but I'm not too sure if, from our review of the discovery, it's not entirely clear if that measure that has been quantified. In any event, we suspect it could be an issue for our defense and our presentation to the jury. So as a result, we're asking to see if the court will indulge us in presenting maybe a draft, a jury charge, or I can reach out to Ms. Paulson and see what sort of jury charge might look like.
You can reach out to Judge Angelini
Okay.
on the 17th.
Okay. All right. Thank you, Judge.
All right, is there anything else? All right, thank you. If you'll give, go to Ms. Ferguson, and she'll give a reset form.
Okay.
All right, thank you for dressing appropriately for court. Just have a seat.
Thank you.
And then, once you sign the reset form, you're excused. And it's the court's understanding that you all have already done a acknowledgement of discovery. Is that correct?
If not, we'll knock one out right now.
All right, thank you.
Thank you, Judge.
Thank you, Judge.
Just give me a moment. Armando Garcia. So, Michael. So,
Judge, probably my clients in the back.
all right, let me see if they're able to bring him out. If not, we'll take care of it. Seth McDonald.
He's up here.
All right, just give us a moment. Everyone, just be patient. I think a chief will come down and try. We'll sit. Oh, Michael Villarreal. Hi.
I don't know what I want.
All right, who's here on Juan Miranda? All right, Norma, Juan Miranda is going to be called tomorrow. Maybe then we'll show a warrant. I'm sorry, not tomorrow. Do it the 12th.
And when you're
All right, now we got the date for Miranda. It's the 12-1 Arturo Miranda. What they pick like? Might want to see the record.
I will try to do what I got.
Thank you.
No, we're done with that.
All right, who's here on Armando Garcia?
President, Your Honor. Garcia, come on up. I conferred with Mr. Yerhan before.
Okay. So is this, detective, what's going on?
Judge, he has the NPR, but he also has a new assault on a public servant, multi-count indictment. I have not looked at that I haven't seen the body cam or any discovery on it yet. I need to do that before we can proceed on the MTR. I don't know why the MTR was kind of set for with the word contested on it, but
Because there's been unindicted cases.
however, it has been indicted since then. In the past month, it's been indicted, so I need to look at that discovery. It's involving 2 police officers allegedly.
All right, and you are on that case?
Yes, I'm on all of it.
So how much time do you have?
I'm just for the standard 30-day reset, Judge.
On this motion to revoke it for 30 days for contested and make sure that his other cases are set at the same time.
I'm out.
Where are you going to be?
I'm going to be in Austin on that day, Judge. Not particularly, but I'm taking that board certification thing on that day.
You're going to be fine. What day?
How about the 8th?
All right, October 8th. All right, we'll be back on October 8th.
All right. Thank you, Judge. Thank you.
Yes. Oh, yeah. Okay. LaShawn?
Yes, Judge.
Brayden Garcia? Sorry, Armando Garcia?
Yes, Judge.
It's 10-10.
Is that good or not?
It's contested, but
You said Armando Garcia?
maybe not.
You said Armando Garcia?
Yes, Armando Garcia.
He told me 10-8.
I thought you all agreed to 10-10.
It's an 8. Mr. DeLeon.
All right, DeLeon. Armando Garcia, is it 10-8 or 10-10?
I'm an 8.
All right, 10-8.
10-8 is.
All right, 10-8, Norma.
Thank you, Judge.
Well, thanks, everybody.